Okay. We are back. It is Monday, the 28th, I believe.
28th of August.
And a lot has happened since we were here last. This is part 3 of our law project discussing the RICO indictment in Fulton County, Georgia. So last time we were here, we talked about some of the main players, the main co-conspirators, the top of the food chain in this indictment. Those individuals, along with the other 14 co-defendants, have turned themselves in. 18 of the 19 have been released. So before we talk about the individual who is still in custody, let's talk about the booking process and the bonds that were able to be worked out, and the speed with which Fulton County Sheriff's Office moved these individuals through our jail.
And we'll give you a little bit of the streets interpretation, because this was big news and is big news in Fulton County in Atlanta, Georgia. And we are a racially diverse community. So there are lots of African Americans, and they have an opinion on how Donald Trump was treated at the jail, which is very different than the way they've been treated at the Fulton County Jail. For instance, nobody knows anybody that got in and out of the Fulton County Jail in 20 minutes.
It's extreme. That's like if they had to stop, drop, and roll. People are given bond and then still wait 72 hours.
Yeah, if they can get a bond, they often get locked up or turn themselves in and then sit for a day or two before they get a judge that would consider a bond. So it was a really unusual situation. It was almost like the circus came to town. A lot of people have questions like, how can this guy have a police motorcade to turn himself into the jail? He's not the president. I don't know if that's post-presidential protocols or if it's part of the Donald Trump, Barnum and Bailey circus routine for TV. I don't know. It was awfully bizarre.
Well, and it's also really interesting that because they were able to negotiate a bond before turning themselves in, they didn't have to experience what a normal person at first appearance experiences. So you turn yourself in, you stay overnight, and the factors that a judge is supposed to consider, in addition to whether or not they're going to be committing felonies, whether there's a risk of them committing felonies, there's also the question of whether they're a danger to the community, okay, and then whether they're going to obstruct justice and intimidate witnesses.
Which is the big one for Trump.
And then whether you're a flight risk. And in Georgia, as it's actually practiced, judges will deny bond just because somebody's from out of town and has another pending case. These individuals, most of them are not from here.
Right. And
several of them that were given bonds have several cases pending elsewhere.
Right.
And so typically they would have been denied bond, or if they were to be released, because Fulton County has some kind of program where they pay for ankle monitors now. So now, like, no matter what kind of crime you commit, the judge will put people who are charged with possession of marijuana with the intent to distribute like an ounce or two on an ankle monitor paid for by the county. None of these people, none of them had to do this.
Much more serious offenses.
Let's talk about the mugshots, and then we'll talk about what happened when these individuals left jail, because some of them made statements, which I think is worth discussing.
Okay, well, the mugshot, the procedure, as we've talked about, it's a rather lengthy process, and it's all part of the dysfunction of the Fulton County Jail. Nobody gets in and out of there quickly, except this guy Trump.
And all of his co-defendants, except for one.
And his people, except one. Nobody gets photographed with their jewelry on. That's one of the streets, like, who is this guy? Just because he's the president, why they let him dress that way for his mugshot? People get stripped down, they get put in jumpsuits, they get put in T-shirts, and Trump's sitting there with a Starch Brook Brothers shirt with a fancy hairdo.
Well, but you can't wipe that look off his face, though, and so that's what I find the faces that some of these individuals made just curious. Like, Giuliani looks evil. Trump's looking reptilian. I mean, he doesn't look human. It's like a lizard or some creatures looking at you. He's got
kind of like a mob reptile look to him.
Yeah, really. But then some of the ladies are smiling. Some of the individuals, I would probably smile in the moment. I'm like, camera's on, and I would have to smile, even though it's not. It's a very serious moment. Okay, but then...
Well, Jenna Ellis looked like a model.
She looked good. That's fine. Yeah, exactly. You can't say anything negative about it. You're like, she's smiling, though.
And I feel bad for her that she got mixed up with these guys. she's in way over her head. But we'll talk about her a little bit later.
What we should talk about now is what happened when Giuliani left the jail and what happened when Donald Trump left the jail. Both made statements to the media as soon as they were released without their attorney standing next to them. I don't know if that was rehearsed. I don't know what was happening, but Donald Trump came out swinging, doing the typical thing where he says, actually, the prosecution and the police and all the investigators in this case, they're guilty of election interference for attempting to interfere with his new candidacy for this president. Yeah, to become the next president. So he comes out swinging and saying the jail was a horrible experience. We were there 20 minutes. I don't want to hear about it. But that it's actually, he didn't do anything wrong.
He's professing his innocence.
Professing his innocence and saying, like, the people that are prosecuting him are wrong. Giuliani gets up there and starts talking about how he's like an attorney and how we're attorneys, and almost like using the fact that he is an attorney as like a front for, like, I guess his ethical duties, like that he would somehow, I don't know, be within the bounds. As he's mad that he's getting in trouble for what he sees as legal representation, which is not what he's accused of doing.
Yeah, so let me just point this out because it's critical. So, and we've talked about this in the past, criminal defendants, presidents of the United States, even lawyers representing individuals, whether they're candidates for office or subjects of criminal prosecution, they can lie, and there's nothing illegal about lying. And that's what their main defense here is. Well, it's a First Amendment, freedom of speech, protected conduct. That's not what's being prosecuted. It's the actions on the lie. It's the
attempt to make things happen.
It's the attempt to commit a fraud, whether that's a telephone call to the Secretary of State of Georgia, soliciting fraudulent conduct, illegal conduct, and creating 13,000 votes, whether it's contacting individuals to become fake electors, whether it's going to Coffee County and accessing private voting records and machines. So it's the acts that's criminal. So when Giuliani...
And soliciting those acts.
When Giuliani et al. And others go about talking alone isn't criminal conduct, it isn't conspiratorial conduct. When you couple it with a criminal action, you then have a crime. You have the crime of conspiracy, and you have a RICO violation if you've committed two or more of the predicate acts. That's the issue. So don't be fooled by, we're just talking. They're not just talking. They're flying all around the country from Michigan to Wisconsin to Georgia to Arizona, Pennsylvania, trying to get people to break the law.
Also, and it's who they're talking to, what the person that they're talking to is capable of doing with that information, and what the intention was in having the conversation with them about doing it. I mean, to me, that's what's going to become like the main core of whether or not it's criminal activity. I do want to say really quick, I initially thought that DA Fani Willis would have wanted to actually argue bond in these cases. And I think other people were like not surprised at all that she agreed to bond.
I wasn't.
I just want to say that part of the reason that that these 19 individuals, 18 of the 19 individuals, had their bonds worked out beforehand is because I do not believe that Fulton County DA's office, the Fulton County Sheriff, want any of these individuals to see the depravity behind the curtain. Right now, in the public, this was a good move to get all their mugshots, okay? And they're like they're going to ride the positive publicity
wave.
About
you didn't want the public to see what really goes on in the jail.
Yeah, they don't want that.
They don't want that
publicity.
sideshow.
They get the positive publicity of having taken that mugshot.
We locked them up.
Yeah, we locked them up.
The mugshots.
Yeah, but nothing about what happens behind.
Yeah,
so I just want to say that.
Spent a couple days in the jail. It's a separate reality.
And it's a reality that if any of those individuals reported on to their constituents, there would be probably, I don't know what there would be next, but whatever the Department of Justice is doing to look into civil rights violations, they'd have people from all walks of life being able to provide some context. I mean, the sheriff's office cannot accept the liability of taking on these men, these over 50, over 60-year-old white men, when their medical providers can't do basic things. I mean, people could die in there. They are dying in there. So that's what I'm saying.
Yeah, they are dying in there.
On that note, there is one of these 19 defendants that is still in custody. Let's talk about it.
Okay, so this is Mr. Floyd. Again, what's his first name? Harrison Floyd. He's from Rockville, Maryland.
Black voices for Trump, or for America.
Yeah, black men for Trump. So he's kind of an anomaly. He has an outstanding warrant or outstanding case.
He has a pending case.
For a misdemeanor, which is a minor criminal violation, carries no more than 12 months in prison or a $1,000 fine. And he didn't have any money, like Rudy Giuliani apparently didn't have any money.
Well, Rudy Giuliani clearly had enough money to hire counsel and to come in on the private jet.
And come in on a private jet, but he's crying he doesn't have any money for an attorney. But Mr. Floyd did not.
He didn't, he didn't work out a bond with the DA's office.
So he's locked up, and everybody else is released, and he's really not a major player in the conspiracy. So,
and he's no more like when you're looking at the 4 factors that I discussed for bond. He's no more of a flight risk and no more likely to commit felonies than the other individuals in the indictment who are actually facing several other criminal indictments in other places. This guy has one charge elsewhere, but he is a black man. He is a black man, and for some reason last week his bond hearing was before Judge Emily Richardson, who is not.
No, are you sure of that?
I'm positive.
Yeah,
and it's not the judge who is assigned to the case. Scott
McAfee is.
She must have been like the presiding judge for the week, and because of the nature of the case, maybe
it's weird.
Maybe I don't know why she heard it, but Emily Richardson denied bond. The one black male involved in this case, saying that he. I guess that he's somehow at risk of committing additional felonies.
I couldn't find the bond order. It makes no sense to me. There's another bond criteria, which is intimidate witnesses or interfere with the process of justice. Trump shows a history of trying to intimidate witnesses and obstruct the process of justice. This guy has no evidence of that. So it's a real concern to me, and also the streets, as we say, are talking about, like, why is this black guy in jail? Why did all the white people get out, and why is he sitting in there? And I don't really have a good explanation for that.
Well, I do, because I know who the judge is, and I've said for a long time I don't. She's a former prosecutor who is having, I don't know. I think she's probably been on the bench a year or 2, but she's clearly had some difficulty transitioning into a neutral role. She is basically a prosecutor on the bench. I have no idea why she heard this case. But it also means that someone from the DA's office had to have argued that he shouldn't get bond, by the way.
Yeah.
Because you don't have a bond hearing where the state, unless the judge went above. It doesn't seem as though the prosecutor presented a consent, like they presented a consent bond to this judge for signing, and the judge says no. I think someone from the DA's office would have had to have argued that he shouldn't get bond.
I can't find the order. We'll report back on that, but it's a concern for all of us here. But
it's exposure that Judge Richardson maybe shouldn't be handling these kind of cases.
Yes, and incidentally, excuse me, Judge McAfee appointed Mr. Floyd an attorney today, and he filed another motion for a bond. So hopefully Judge McAfee and counsel can get this matter resolved expeditiously. But we do not want to see this gentleman sitting in the Fulton County Jail, particularly with the allegations of his part in the indictment and the conduct which he's accused of.
But it just exposes the unfairness of the system, who you get on the wheel, what judge. Yeah. Because I have a feeling that Judge McAfee is going to be very reasonable and set a reasonable bond. So for a judge in the same courthouse who have reviewed the same information and denied bond should concern everybody.
Yes.
Because people's lives are at risk. Again, this isn't like, it's just terrible. So, okay, what we should talk about next is what's coming up.
Today we have this removal issue before Judge Jones in the United States District Court, Northern District of Georgia. It's brought by Mark Meadows, and I believe Sidney Powell and maybe someone else have joined in on it or have filed their own. But it basically says that the conduct which we're accused of, the criminal conduct which we're accused of, stems or grows out of my function as a federal official, and therefore the Supremacy Clause of the United States Constitution preempts state action, and my matter can be heard before the United States District Court here in the Northern District of Georgia, the Atlanta Division. Now, what does all that mean? Well, the translation is, I don't want to sit before a jury in Fulton County where over 50% of the potential jurors are black, where the
very liberal,
very, very liberal, where Trump has done very poorly in his elections. I want to get before a federal court, pardon me, where the jury comes from a much larger area, the Northern District, which includes South Fulton County and North Fulton County. North Fulton County is overwhelmingly white and a lot of Republicans, so it's much more conservative. As trial attorneys in Fulton County, we're very suspect.
I think it should be 2 counties
of
myself.
Georgia, of potential jurors from Roswell, Alpharetta, Johns Creek. We don't preemptively exclude them, but we look very closely on whether they can be fair and impartial.
They're not really a jury of the peers,
Yeah.
but more of a jury. Yeah, so Trump could get a fair jury if Fulton County handles their the DA's office strikes the same kind of people they strike in their gang murders, which would be black people.
Well, wait. Let me I'd like you to discuss that, but first, let me mention that in the federal court, the district court, you have a lot of federal judges, and many of them in the Northern District were appointed by Donald Trump. Now, Judge Jones was not a Trump appointee, and that's who's hearing the Mark Meadows matter. But that's the strategy: get me away from the county. Get me in a friendly venue, which is the federal district court, get me before a Republican judge, and get me before a jury pool, which is much greater percentage of Republican taxpayers. So that's what's going on.
That's nice, but legally, I don't think that there's much precedent for their argument that it should be removed. I'm not sure if these lawyers have practiced much criminal law, but I mean, how many times have you asked for a state court case based on state court claims in a criminal matter to be removed to federal court in all of your years?
Never.
It's not. I feel like it's like they're mixing up civil and criminal law,
Yeah.
and they're mixing up being accused of criminal activity with acting in furtherance of an official government position. Like, you're not being accused of acting in furtherance of your role with the government. You're being accused of crimes. That's the difference.
Yeah, and let me note that Donald Trump tried this when he was indicted in New York in the state court of New York City. I think it was Manhattan. And the district court, the federal court in there, denied his request to adopt the case and transfer it to the district court. So there is some precedent with Trump's conduct. That was a little different. That was the Stormy Daniel matter when Trump was a candidate for a federal position, be it the presidency, but the federal court said no.
But was that a criminal matter?
It is a criminal matter now.
Well, now, what do you mean? What is?
When Trump was charged in New York for the Stormy Daniel matter, they tried to remove it.
And that was a criminal matter?
I think so, yes.
I don't know. All I know is, what's the likelihood that you think that they'll be able to get it removed?
I don't know. I think Mark Meadows has an interesting argument, and I think it has some merit to it. He was the chief of staff. He was a political official, and he's now extending... He was a
governmental official, not a political official.
Well, that's right. He's a governmental official, and then he's now out politically trying to rig an election. The way I understand it is this. The mailman is a governmental official. But if the mailman's out stealing your mail, it doesn't mean he gets a federal trial. It means the state can prosecute him for theft by taking or theft by conversion.
Especially because the law that the state has indicted these individuals for is not the same in the federal system.
That's true. Yeah.
So I guess so I don't think it's likely that this judge is going to grant.
The hearings today, we'll see. It's an interesting argument. He's basically...
I don't think it's that interesting. No, I think it's desperate.
Yeah, it's an argument saying, get me out of the state court, get me in the federal court, because my conduct is related to my job as a chief of staff, or my conduct is related to my job as an attorney for Trump. Re-election committee. So
Again, that's what I'm saying. Campaigning with your political motive behind it is different than your government job.
Yeah, that's right. It's not even President Trump. Well, he's got a duty as a president, took an oath to uphold the laws of the United States, to do his official business. There's a whole separate firewall to the candidacy and the committees to reelect the president.
They've been blending it.
Yeah.
They've been blending it, and it's going to become a bigger issue now that they're out on bond with some specific conditions to not try to influence other witnesses. And I'm not sure if she put in a no-contact order between co-defendants.
She put a no-contact...
Without an attorney.
Without an attorney, yes.
Yeah, so
she did.
So like Donald Trump and Rudy Giuliani are not going to be having any sort of conversations without their attorneys involved. But their attorneys all know each other, so that's
well,
not
they
gonna
should
hard.
be. So let's talk a moment about this attorney conflict issue. Rudy Giuliani says he's broke, says he can't afford an attorney. Apparently goes to Mar-a-Lago and asks to get some money for an attorney. And now we have this dinner in Bedminster Country Club, $100,000 a plate, where Trump's going to have a dinner for Giuliani to raise legal fees. Well, that sure looks like you're buying your co-defendant and you're buying your witness against you to me. Because the converse of that is, if Rudy Giuliani is left hanging, where he's broke and he can't afford an attorney, he's much more prone to make a deal. You know, some sort of plea bargain or some sort of agreement for dismissal, possibly, if he's not on the hook to Trump for money to pay for his counsel. And that goes to all the co-defendants, one way or the other, that are getting paid for counsels through Trump or through some Republican committee. So there's a process in the federal court called a Garcia hearing, and I suspect that Fani Willis and whoever prosecutes the case will bring that similar motion in the Fulton Superior Court to look at what type of conflict these guys have and who's paying for who and how does that affect the objectivity of their defense. And so we'll see. We'll see what happens.
Yeah, I'm just trying to think about it like on a lesser scale, like when we have co-defendants and like the co-defendant will pay. So I think you do have to. The co-defendant will pay for like the co-defendant. You know, it's
an ostensible conflict of interest.
It is, and you have to look closer at whether their defenses will affect each other. And in this case, unless they all, I mean, the global defense is that they were just checking the machines.
Yes.
It's going to be. We should talk about too the fact that some are filing speedy trial motions, and what does that mean?
Well, that's interesting. Chesborough filed one, and I think Sidney Powell filed a speedy trial. There's different federal speedy trial issues. The speedy trials is in the Sixth Amendment to the United States Constitution. Georgia has codified it. Codified it in Title 17, and it says that you must be tried in the term you've been indicted or the next succeeding term. And Georgia's terms are, I think, 2 months. So that would mean like in 4 months post-indictment they would have to be tried. So what I think Judge McAfee has done is severed out Chesborough and said you're going to have a trial this date, and maybe Sidney Powell will be on it. But it's a good vehicle to use, a good procedural vehicle to use for a criminal defendant, because oftentimes the prosecutors aren't prepared to go to trial. They have enough to get you to the grand jury and get you indicted, but not enough to call their own witnesses and present their evidence. So Chesborough is making a move.
It means that they have to try the case within the next 2 terms of court, which is basically like in the next 6 months, definitely. Because I think the terms of court are like 2 months each, so 4 months maybe.
Yeah, so it's a very quick term. But the talking heads are saying that Fani Willis was prepared for this.
She said she was.
Said she wanted a speedy trial, said she's prepared, and has agreed to put this case on the calendar expeditiously. So it's an interesting maneuver, one of the first real legal maneuvers we're seeing as this case starts moving toward arraignment and trial. Let's just comment also that Donald Trump changed counsel on the eve of his booking. He had Drew Finley, who's a friend of yours, right? And he went to Steve Sadow. Both of them are very good lawyers. They have excellent reputations here in the state of Georgia. Steve has a lot of federal experience, and Steve will try state cases.
And I think that Steve actually would probably get along better with Trump. I was telling, I don't know if I told you this.
You told me that, yeah.
I just, personality-wise, I think Drew, I'm happy for Drew, honestly, that he doesn't have to get involved with this, because I think it's going to be, he got the benefit of getting to do all the biography on who's Trump's attorney, and it's like me, and he is like a flashy, good lawyer he's a great lawyer, and he's a lawyer to many, stars, and maybe Trump needs a little more hand-holding, but also someone who's a lot more like him in delivery.
Yeah.
Steve Sadow is pretty formidable and authoritative is what I would say. He
similar to
Trump.
Trump.
Yeah, he gives off those vibes.
So the key is, with lawyers and trial lawyers, it's not necessarily how well educated you are. It's whether you can work and control and operate in a courtroom. And both these fellows, Drew Finley and Steve Sadow, are experienced in that. and are very good at it. They're bright guys. They know the law, and they'll do well in a courtroom. And I think Steve will do a great job, and I think Drew Finley would have done a great job. I have some questions. I don't know if this is the proper time, but there are several lawyers that came out of the DA's office that I'm wondering, why aren't they there? Where's Clint Rucker?
Oh, he's talking on the news. What do you mean?
Well, he's been a great lawyer to be in this case. He knows the RICO law. Paul Howard, I don't know if Paul would be a great one, but Gabriel Banks would be another great one.
Well, we don't know who's, I guess some of these.
Yeah, we don't know yet who's all in.
Also, some of the lawyers that are on the Young Thug case probably would have been tapped, and Brian Steele definitely would have, and Bruce.
Bruce Harvey should be in there.
No, I'm so glad he's not, for his health.
Yeah,
it's going to swallow years of these attorneys' lives. Mm-hmm. And it's just going to be very difficult. So that's what's happening with the speedy trial. I personally think that kicking is like kicking a sleeping dog. No one should kick a dog ever. But filing a speedy trial motion when you've got so much to lose, I think it's like kicking a sleeping dog and fuck around and find out, basically.
In a criminal defense world, time is your friend. Time almost always works to your benefit. So that's the opposite of the antithesis of a speedy trial demand. You just want to, and Trump's a master at this. He knows it. You delay, you change counsel, you file motions, you're unavailable, your witnesses can't make it, whatever. Just an infinite number of excuses to delay it. And then the political landscape can change. The interests of the prosecution or the state or the federal government to go after you can change. There can be a new election that can change everything. So none of that happens with a speedy, or very little of that happens with a speedy trial demand. You are on the hook, get ready, and go to battle.
Yeah, whatever it is, you don't even have the right to the same discovery. I don't think.
Whatever's in the state's possession, you have a right to it. More may develop after your trial starts.
Yeah, I'd rather be the last one hanging than the first one.
Me too.
To fold.
Me
but
too.
I think that's just me. I'll hang on the whole time because, I just don't. If you're innocent, possibly fully innocent, and we have an alibi, some major proof that you had nothing to do with this, and he's free though. So it's if somebody's in jail, I can understand a speedy trial more as well. When you're sitting in jail and you just want it to be over. Even then, it's you don't want to rush this because this is a very delicate matter. What's going to be very interesting to me is if he rescinds his motion, basically.
Well, that's always a possibility.
That to me is the worst. From a criminal defense perspective, you just basically called your own bluff. You just said, I want a speedy trial. You get them all ready, and then you're just kidding, I need more time.
So let me just comment on the basics of the RICO. So in this case, because it's so well publicized and so well documented, there's going to be an admission that the individuals said the comments that they said. And in fact, Trump was actually recorded in that private phone call to Secretary of State Raffensperger. The next issue is, because there's going to be witnesses, they're going to have to admit that they did the acts that they're accused of. That I did contact, David Schaefer, former head of the Republican Party in Georgia. David James Schaefer, former head of the Republican Party, and I did ask him to be a fake elector, or be an elector. So the defense is going to get down to something very specific, I thought it was legal.
Or I was authorized to do it because I was told by somebody above me.
I was told by the president to do it. I thought it was okay. So it's going to get fairly simple. This complexity of the RICO statute will get distilled down to some very simple issues okay, you thought you could steal, but you didn't have the authority to. You thought you could sign this document that said you were an electorate, but you weren't truly appointed as the
attorneys
electorate.
Are going to get slammed on these things.
I think so.
That's when Rudy Giuliani came out with his statement after he got out of jail and was talking about basically being an attorney is criminalizing himself as an attorney. It's no, again, we talked about this last time. You have ethical duties to know where the scope of your representation ends. Mm-hmm.
What's the bright line?
Yeah, and there's bright lines.
And we all know them, too.
Telling your clients the truth and versus coming up with lies for them. I mean, those are the...
Yeah, I mean, it's like somebody coming in here saying I have an alibi, and the alibi witness comes in, and you ask them, well, was he really there? And they go, no, but I'll just say it. And you go, no.
You can't, I'm not participating in that.
I'm not going to let you sign an affidavit. Not do it here. So that's what's going to happen here. These guys are going to have to admit the comments. They're going to have to admit to the tape-recorded conversations. They're going to have to admit to the documents that they signed that were notarized and submitted.
But then try to claim.
And then they're going to have to go, oh, Trump told me to do it, or Trump's lawyer told me to do it. And it's not going to sell well on Main Street, but that's what this very complicated RICO case will distill down to something very simplistic.
Because they can't get away with the facts.
They can't get away. That's right, because they're caught in the act, basically.
They're stating things kind of publicly or in conversations that are recorded.
Or they're submitting the documents for recordation. That's the other thing.
Oh, I should talk about now really quick. Did you hear that the House committee is investigating, or that somebody's going to be investigating Fani Willis? Do you see this? This
is why time is your friend in a criminal defense situation. This is a considerably damaging procedure. The state House and Senate in Georgia rushed through a bill, which
before this.
Well, as this thing is pending, right before the indictment.
Yeah.
But as the case is pending, which Brian Kemp, our governor, authorized, that said that the governor could remove prosecutors in the state of Georgia. Now, Florida has this statute under DeSantis,
and he's been using it.
And he's used it twice to remove Democratic, duly elected district attorneys. Now, Fani Willis is an elected DA in Fulton County, Georgia. But now we have this statute on the books, and we have a Republican member of the Georgia Senate or House that says he's going to bring a motion. I think it goes into effect October 1st or October 15th. He's going to bring a motion expeditiously to have Fani Willis removed. It's a problem because then it goes to some committee, I think, that's appointed by the governor to decide whether she gets pulled out of her job, gets basically terminated.
And I do.
So it's real concern.
Yeah, well, it's dangerous, especially with the way that the makeup of the committee, I believe, is likely not going to be helpful to a liberal prosecutor.
And
however,
she's not even liberal.
And that's what I want to say is that so Kemp. Okay, so Governor Kemp and DA Willis are probably more closely aligned, despite them having political disagreements about certain things, than Trump. I do believe that Governor Kemp is trying to be part of a newer Republican Party that doesn't want that will not allow his own integrity to be ruined,
to be compromised.
And he made that pretty clear back when this whole thing happened. And him and Trump, there was tweets back and forth. It seemed like Trump bullied him.
Tried to intimidate him.
And so I don't think that Governor Kemp is going to whatever extent possible that power that he has, he's not going to go with that.
Okay, well, okay. How about this though? That Governor Kemp's term's expiring. He's a two-term governor. He wants to run for the Senate of the United States. He's going to need the Republican National Party behind him. If the Republican National Party gets behind this, get Fani Willis out of there, then Kemp will get to appoint another DA, and that DA says, I'm dismissing this charge, it's a witch hunt. Boom. Then Trump may get carte blanche treatment. I mean, this is just a theory to run for the Senate of the United States and get a lot of national money for his campaign.
Maybe that's why Fani wants to try this so quickly.
I don't know, but this is not something to be taken lightly. That's one of those corruptible statutes that can be employed right here that can just vacate the state's power to see the rule of law enforced against the Fulton 19 and the Trump mafia family.
On that note, September 6th is the arraignment. I don't know in arraignments whether you plead guilty or not guilty to the charges. They can be read out loud. The reading of them can be waived. Usually, the attorneys before an arraignment will waive formal arraignment and enter a plea via a filing and then be excused from court. I read somewhere that Judge McAfee is going to have these individuals coming in 15-minute increments. I don't know if they're actually physically going to come or whether they're going to waive arraignment and these things aren't going to happen. I don't imagine that anyone's going to be entering a plea of guilty. At this stage, at the arraignment stage. It's just the beginning. It's a formality to plead not guilty. It's so that you can get discovery and litigate these issues. At some point, many of these individuals may enter pleas and resolve their case short of trial. But this is just the first step. Will be September 6th in front of Judge McAfee.
Yeah. So the issue there is, will Judge Scott McAfee allow the individuals to sign a paper that says, I waive formal arraignment, I plead not guilty? They file it and they don't have to come to court. I'm not sure what Judge McAfee's protocols or procedures are for this. Rachel seems to think Judge McAfee will allow that in this case.
I don't see why he would make them all come in
I don't either.
and create the media
and what that
show.
does, it does two things. It notifies the court officially who the counsel is, because the lawyer presents the document to the court, and it's an official plea of guilty or not guilty, or if you stand mute, it's a plea of not guilty. So that gets the formal ball rolling.
He'll at least maybe do Zoom if he doesn't just excuse them all.
Yeah. So and
then he'll hear bond for Mr. Floyd. Hopefully.
Well, they hopefully hear that beforehand. But the real issue, which I guess we should do it on another program, is the art of plea bargaining, because that's the backstory to the prosecution of 19 individuals here. Like
chips will fall.
Chips will fall. Who's going to flip? And how bad can they flip? And that gets back to what I was saying earlier about, you're paying these guys lawyers, they're not going to flip on you. When Trump's head of security down at Mar-a-Lago had a Trump-appointed lawyer, he went in and apparently lied to the grand jury. He decides to get his own lawyer. They retract the statement. Now he's telling the truth and he's a cooperating individual. So the flipping...
Well, for a lawyer to allow that, see, if you want to pay for... This is ethics. If you want to pay for me to represent this person, that does not allow you to control what I do with this person. Their best interest becomes my only interest. Your financial interest is separate, and it's so that he has his interests protected, not so that I do what you say.
Yeah.
The lawyer has to be strong enough to create those ethical boundaries, and it's disturbing how many are not.
Yeah, and on a more personal level, the defendant is scared to death. He's looking at a term of incarceration, and some guy, whether it's a co-defendant in a drug case or the former president of the United States, is giving you money to get you out of jail and to get you counsel. So these necessarily often are not sophisticated people, and they go for it. I think it happened with Michael Cohen until he got rid of his legal ties to Trump and the Trump family, that he straightened his case out and decided that he wasn't going to lie, he was going to tell the truth.
How long will they hang on to the lie? And that's going to be the chips falling. Some people will fall faster, some will stay loyal, because that's apparently what they believe is most important.
Yeah, so that's a really interesting part of this case, because there's so many co-defendants, and many of them should work deals because
they have a lot to lose.
They have a lot to lose, and they're in a very good position to make a deal. Some of them don't want to lose their law license, which is going to be tough if you enter a plea of guilty to anything. You're pretty much assured you're going to lose your law license.
They can write a book or something.
Yeah, but still,
Well, that's how you end up in these situations, is when you don't create the boundaries up front and you participate in this kind of outrageous activity that is also criminal.
Yeah, I mean, Jenna Ellis is a lawyer out somewhere, out in no man's land.
Well, I was on Piers Morgan, the other night, and there was, I think, Trump's former, I don't know if you listened to it, but one of his former spokesperson got on after me and was just, people just not in touch with reality, just not in touch. And I wanted to respond. I was telling him on my little mic, I'm like, let me get on here, and they didn't have more time for me.
Was it a woman?
Yeah.
Okay. Well, he's got another spokesperson
Full of shit.
named Alina Habba up in New Jersey, who's just contradicting everything Trump says. She's way out of her league. She's another attractive white female. She says Trump doesn't need any time. He's a brilliant guy.
Does she have dark hair?
She's a brunette.
Yeah, it's the same girl. She was
Yeah.
Shockingly, I'm like, what world are you living in? We're living in different worlds.
Well, and she's living in a different world than her client, because client says this is complicated. Trump says this is complicated. I need a lot of time. I need to postpone it till something like 2026. She's on TV saying, this guy's brilliant. He knows everything. What's there to be alarmed about? He can do this. He doesn't need a lot of preparation. So completely disconnect.
No, but just like his, I mean, just his biggest fan in a way that is not in touch with reality. That's like.
And listen, he did this earlier with another girl, another lawyer, Christina Bobb. He had her sign documents submitted to the FBI, I believe, that all the classified information had been searched and there was nothing more at Mar-a-Lago. I mean, the girl got herself in a lot of trouble. She still may get indicted. She could lose her law license because she fell under the spell of the Trump and the Trump world of miscommunication and outright lying. And so now you got Alina Habba saying the same things in a different context, but she needs to be careful.
They're lemmings. They're programmed to just like ignore, and fire off on his behalf.
But they're going to get in trouble.
Yeah, following him. So that's the thing. At some point, people are going to realize following him probably isn't best for my freedom.
That's what Michael Cohen keeps saying. He's going to throw you under the bus. He's going to get you in trouble, and you're going to go down. So beware.
Well, on that note,
beware.
Happy Monday. Yeah. We'll come back soon with some updates.
Come back. We'll see what happens with Judge Jones here on the Mark Meadows motion, and we'll talk a lot about the remaining co-defendants and also about the art of plea bargaining and what it entails. So thanks.
Thank you for watching. See ya.